I'll again ask for 5 minutes rebuttal. May it please the Court, I represent, again, the appellants in this case, CHARLENE Mooney and Kevin Westman. Ms. Mooney was driving a vehicle owned by Mr. Westman when she got into a motor vehicle accident with Mr. Horton. We're asking for a new trial based on evidentiary rulings, failure to remedy an improper jury instruction, and an improper tribunal based on juror nondisclosure. I'd like to start with the jury instruction issue. In this case, the trial court erred when it failed to remedy an inaccurate and inapplicable jury instruction regarding the sole element of damages that were at issue. And that element was the future non-economic damages of the decedent's 3 children.
Did you agree to the jury instruction?
Inadvertently, trial counsel did not object to it during the charge conference and allowed it to be read. However, because this amounts to a fundamental error, because it goes to the heart of what the damages were, we believe we meet the Castor versus State requirement that we did bring it up as soon as possible and, most importantly, gave the trial court an opportunity to cure. And that's the important thing.
As possible would have been when the jury instructions were drafted, right?
As soon as possible after it was realized, Your Honor. I agree.
Were the jury instructions read to the jury on one or more occasions before this objection was raised?
Yes.
Okay, on how many occasions? In what context?
I believe they were read after the jury was impaneled and then after the parties rested.
And then when was the objection actually lodged?
The objection was lodged, if I'm not mistaken, during plaintiff's closing argument when he was talking about the future damages of the children and how long they were going to live. That
So all the evidence was closed?
The evidence was closed.
When it was raised, it was past the time for the plaintiff to be able to put in any other evidence or do anything different?
I would agree with that, yes.
Okay.
Yes.
As far as closing argument, would you agree that attorneys, one reason you have the charge conference before closing argument is that attorneys use what they learn in the closing argument, learn in the charge conference, and they argue that. They'll say, the judge will tell you this, and then they'll say argue why that instruction supports their client's position. So, if the judge sustained the objection, the plaintiff's attorney would have just told the jury, the judge is going to tell you this, and this is why it helps us, and then all of a sudden you want the judge to say, no, you can't argue that, that's not what I'm going to tell him?
No, Your Honor, I understand what you're saying about how a trial, I'm mostly a trial lawyer, so I understand what goes into preparing a closing argument, and you do rely on things. However, this was not the first time this came up. This was actually discussed pre-trial during, we proposed jury instructions that had the proper language, and actually it was discussed right before trial started where defendant's trial counsel did raise the issue saying, I don't think the life expectancy of the children is the right measure. I believe it's joint life expectancy of each. Why there was no objection raised, I can't say.
Right.
But
at the time the judge got the objection during plaintiff's counsel's closing argument, if there's going to, that situation was caused, you'd agree, by the mistake, if you would, of defense counsel for not raising and not objecting to the instruction. So why should plaintiff's counsel bear the consequences of defense counsel's mistake as opposed to having defense counsel bear the consequences of defense counsel's mistake? Because I believe we complied with the Castor v. State requirements that it be raised contemporaneously. And that doesn't necessarily mean immediately. It means with enough time to give the court notice of the fundamental error, which this was. This is the only element of damage. And they awarded them $300,000 each based on that. But what it did was it gave the trial court notice of the allegedly improper argument, instruction, but it also gave the judge, more importantly, time to cure it. And so there are a number of ways to do that, and some of the cases we cited explain that. What the judge can then do is tell the jury, look, there was a mistake, you should ignore the previous instruction, this is what you should listen to, and this is the instruction you should follow, and then also give them a written instruction to take back with them into the jury room. To the extent that the plaintiff may have been prejudiced by losing time on his closing, that could have easily been remedied by giving him additional time or recessing to allow that to be remedied. There are any number of ways to cure this, but the important thing was this went to the fundamental.
Well, counsel, is your only argument on this point? Do we have to find that it was fundamental error for you to prevail on this point?
I don't think you have to. No.
Well, how do we get past Rule 1.470 then?
Because I believe the Castor versus State,
Rule 1.470 says that you have to make an objection at the conference, and that if you don't, you cannot assign error to an instruction. I mean, it expressly says that. So do you concede that you did not make a timely objection on this instruction?
I'll concede that the rule was not followed.
So how do we get around Rule 1.470 other than your fundamental error argument?
I'll concede that. Fundamental error would be necessary to get around this. But I believe we've followed the Castor versus State requirements for fundamental error.
What's your best case in support of your contention that an improper jury instruction in a civil case on a measure of damage would constitute fundamental error?
I believe that would be the Castor. I'm sorry, I don't have that.
Criminal case, right?
Yeah, I'm sorry, I don't have that on the top of my list here. It would be in the briefing if it was.
Now, the nature of the error was what?
The nature of the error was, and what we requested prior to trial and during trial, during preliminary discussions before the jury came in, was that the measure of damages in a wrongful death case, there are two options, and I'll admit that. There are two options in the jury instructions. The first one listed, though, is the one that should have been given, and that is that the measure of damages for a surviving child should be measured by the joint life expectancy between the child and the decedent. And unfortunately, the jury instruction does not go into what a situation with an adult surviving child. What we have is, some minor surviving children, and we've briefed that issue. But what was given is that the jury should consider the life expectancy of each, and that's the second option. And that talks about
Each being?
the children.
All right.
And so when you're only considering the life expectancy of the children, and I get that, there may be some arguments that, and some of the courts address this, a child may feel pain and suffering about the loss of a parent for the rest of their life, regardless of when the parent would have died. But the courts have held that that's not proper, because at some point that parent is going to pass away. And that's where the pain and suffering stops. And so that's why that joint life expectancy is so important, because you have the joint life expectancy here, but then you have the child who's probably going to live maybe another 20, 30 years. That's substantial, and that's what was argued at trial. And that's what's borne out in the verdict, $300,000 for each. That's a not insubstantial verdict.
Each of the children got the same amount, irrespective of the fact that they were different ages, right?
They were all adult children, but yes, they're not all exactly the same
What
ages.
kind of age spread between the kids?
I believe they were, I want to say they were in their 20s. I'm sorry, I don't have the exact ages in my...
The fact that they each got the same amount of money, wouldn't that be some indication that the jury didn't calculate it for each kid based on the kid's age or the kid's life expectancy? Because they would have different life expectancies, presumably, right?
Well, yeah, exactly, they would, but I'm not going to speculate what the jury decided. What I do know is that they were given the argument that they shouldn't just consider the amount of time between when the father would have passed away and when he deceased, but beyond that. And how the jury took that into account, that's speculation, I can't say. But $300,000 is a sizable sum. However they took it into account, they heard it. They heard all of that. And that was not, it was not dealt with gently at trial. It was discussed repeatedly. They had witnesses come in to talk about how this was affecting the children. They had the pastor from their church come in. I mean, this was the sole element of damage. This wasn't just, they gave them $10,000 each in addition to the estate getting $800,000. This was all that was at issue here. This $900,000 they got, that's all we're talking about.
But it's one way to look, as a follow-up to Judge Palmer's question, it's one way to look at that is if one child had a 30-year life expectancy and another child had 40, that they didn't give anything for the last 10 years, so why would we think that they, were given more at the end as opposed to, put it all at the front as far as pain and suffering?
I would say that's speculation as to what how the jury took that information and considered it. All I know is they heard the information, they got the improper instruction, and what they did with that, they did with that. However they interpreted it and analyzed it and added it up, they got the sense that the damages should be higher than they should be under the law. And that's why I've cited to the Bell South Telecommunications case. This is a Florida Supreme Court case. Talks about minor children, but the language in that is that the only way to, it said that even though the child's pain could be lifelong, the only way to harmonize the various provisions of the wrongful death statute would be to consider the joint life expectancy of the child and the deceased parent. And there are other cases cited as well. We also have, cite as error, the exclusion of the accident reconstruction expert, Alan Moore. Plaintiff's position at trial in this case was that Mr. Horton had made a proper turn on a green light from the left turn lanes on Route 40 and was only hit because Ms. Mooney ran a red light through the intersection. Defendants at trial sought to rebut the argument by introducing testimony of an engineer, accident reconstructionist named Mr. Moore. The trial court cut out his opinions. He was prepared to testify that it was more likely than not that Mr. Horton's lane was available to him to run a red light, and that Ms. Mooney's signal was not available for her to run a red light. This was similar to what he had done in many other cases. He testified to that. Any questions about how he went about doing that should have gone to the weight of his opinion, not to whether it was admissible. He also testified that it would have taken Mr. Horton about 9 seconds to reach the point of impact, assuming that he began at a green light. This is based on sequencing and timing of lights. This is not necessarily based on a traffic study that somebody may have a question about, even though he explained his traffic study, explained that it went through the FDOT manuals and actually exceeded the requirements for them, things that he does all the time in his line of work. And that he also would have opined that Ms. Mooney...
Does in his line of work not to say whether somebody ran a red or a green light, but to look at the traffic flow, right?
To look at traffic flow and opportunity to run a green light, I believe was kind of where he was going with it. He can't say that she actually ran a red light. There's only one person, and that's another issue, who would testify to that. He can say, look, I know the sequencing of the lights. I've confirmed with the city. I've looked at the sequencing plans, and based on the testimony that we have, based on the evidence, it's more likely than not that Mr. Horton's lane was available for him to run a red light, as opposed to Ms. Mooney's lane being available for her to run a red light based on what we know. And that's based on hard evidence. That's not based on guesswork. That's based on things that he testified, that he reviewed, that he went to the city and confirmed and presented to the judge. And that should have been given to the jury.
Was this a Dobert challenge?
It was a Daubert challenge, yes.
Okay, and what evidence did your side have to meet the Daubert test?
He discussed the study in great detail. He went through how he looked at the turning movement of the turn lane. He evaluated the signal timing, and in order to determine that, he went...
That's what he did, but how does it meet the standard for the standard in the industry? Was there peer-reviewed articles? Was there peer-reviewed opinions that this was a valid methodology, et cetera?
I believe he went through the fact that it was... that he had performed it many times before and actually abided by the FDOT requirements, which itself were peer-reviewed. And so by abiding by those requirements, he would have met that standard.
FDOT requirements to do it for what purpose? It wasn't to give the probability that somebody runs a red light, is it? Is that what do the FDOT studies, is that what their purpose is?
Not probability to run a red light, but availability to have these red lights available.
But he was going to testify that it was more probable that he ran the red light than she did, right? Isn't that what you said? He was going to testify it was more likely than not that who ran the red light?
That it was more likely than not that Mr. Horton's lane was available for him to run a red light.
What's the relevance of whether it's available to run a red light if it doesn't establish probability of whether he did in this case run a red light?
Because the entire case hinged on liability on whether or not Mr. Horton actually ran a red light or went through a green light. And so plaintiff's position, and they had their own accident reconstructionists talk about these things. We were going to rebut that solely with the testimony of Mr. Moore, who was going to say, we don't think that's actually the case. The evidence based on the sequencing of the timing and the lights shows that it was more likely than not that Mr. Horton's lane was available for him to run it and not Mr. Mooney and Miss Mooney's.
So for example, if you had an intersection with just a straight light, green one way, red the other.
Yeah.
And somebody testified that it's green for a minute going this way, it's only green for 30 seconds going this way. Would that lead to the same conclusion, that it's more likely that this person ran a red light because the light was red more of the time at that intersection?
That may, but that's not.
That would be acceptable testimony on whether or not they ran the red light is because the light is longer one way than it is the other?
In a given case, it may bear on some issue, but in this case, what we have is kind of a unique layout. And what we have is straight lanes and then a left turn lane that kind of a median between the straight lanes and the left turn lanes. So the sequencing becomes very important. The sequencing is not straight northbound, southbound, eastbound, westbound. It's a number of lanes northbound, southbound, but then if you want to turn eastbound, westbound, you have to actually go off the road somewhat and hit that. So in that kind of situation, you have tendencies of people to, if they miss that exit, I guess, to turn left, people can go straight and make an improper left-hand turn. So all of these things were at issue here. This wasn't a straight-up, simple intersection. And so that's why Mr. Moore's testimony was especially important in this case.
You're into your rebuttal time.
Thank you. I'll rest on my briefs for the remainder of the arguments.
Okay.
Good morning. May it please the court, my name is Chris Carlisle, and I'm here on behalf of the estate of Mr. Mooney. Your Honors, turning to the jury instruction question, I think that there's no doubt that the court has gotten to the point where we all can agree that there was a waiver of this issue before the trial court. What's interesting about their initial brief in response to Judge Eisenachel's question was they didn't concede that. They argued that other things occurred, and only in a footnote did they mention fundamental error. When we pointed out in our answer brief that the rule requires this to be made at the charge conference, when we pointed out in the answer brief the trial court's comments where this was raised during closing, in the middle of closing, that on the motion for new trial, the court came back and said, that was also argued extensively, I believe, at the time, and now briefed more fully, and it was not objected to. I read it twice. Not only did I read it twice, it was agreed to prior to the reading. We had the charge conference. I repeatedly asked both sides about the jury instructions. There was never a problem by the defense as far as the jury instructions go. This is the trial court expressing her opinion and exasperation about what occurred here. Going to Judge Evander's point, the reason we have charge conferences, the reason that we know in advance of closing argument what the jury instructions are going to be is to allow counsel to then prepare a closing argument in accordance with those jury instructions. To suggest that somehow, despite the fact that counsel have prepared this argument, we can stop closing argument, give an instruction, and say, by the way, redo your closing argument and come back tomorrow and we'll give it to the jury then. There's a reason that that rule exists, and it's so stringent. There's also a Supreme Court case that we cited in our brief called Universal Insurance Company from 2012, which has the sentence, fundamental error is also waived, where a counsel affirmatively agrees to an improper instruction. Again, the Supreme Court seems to be suggesting this is so important, and you obviously have tremendous amounts of time to prepare and focus and draft jury instructions and argue them that you can't even get there by fundamental error once you agree to it. Transcript page 911, defense counsel, they look fine. That's the response when the court asks about the jury instructions there. So again, I don't think there's any doubt, and they in fact conceded now, the only way they get there is fundamental error. I don't believe that the fundamental error analysis gets us there based on the Supreme Court case we filed. And finally, the argument that you heard concerning whether or not it's a minor child or an adult child, you heard a concession during that argument also, that the jury instructions provide alternatives and they do not go into whether or not it's an adult or a child. You heard about a Supreme Court case talking about when it is children, that is the measure, which was decided, I think, 14 years ago. And the jury instructions have never been amended or specifically have a note in them that says when you have adult children, this is the instruction you give. And so to suggest that this was clear, it was fundamental, it was absolutely the case, is simply not the case. And the jury instruction does not require that. The statute that the jury instruction relies on does not specify that or require that. So even if this court gets to the point where it's considering whether or not fundamental error was considered, it is not the case. And there is not a case that says this is the instruction that you give in this circumstance. Turning to the second argument that was made, and again, I would point out, and the court was aware, that there were 6 issues raised here, all of which were subject to an abuse of discretion standard. We pointed out in our brief that the trial court spent considerable time on these issues, including in response to a motion for new trial where a lengthy hearing was held. On some of these issues, the trial court heard them on 3 occasions. For example, a motion to eliminate, another objection at trial, and in the motion for new trial. And as this court is well aware, when we're considering discretionary decisions of the trial court, the standard is there no judge in the world, or no reasonable judge that would have made the decision the trial court made. A lot of these were evidentiary decisions that went on during the course of trial, including the decision to exclude the accident reconstruction report of Alan Moore. The court had a lengthy hearing on this where it heard all about it. It issued I believe, a 3-page order explaining in detail why she did not believe that this met the standards that were appropriate for this. She stated the defendant did not identify any empirical data, research, or study to indicate that the use of the procedure outlined in the FDOT manual on uniform traffic studies is reliable in determining the cause of a traffic crash, which is exactly what Judge Palmer asked about here. Where is the material that I'm going to be convinced gives you the ability to render this opinion? It was not present at trial. There was a traffic study that has nothing to do with the ultimate decision or the ultimate opinion that he was being asked to render. And again, the opinion was that the plaintiff was more likely to have run a red light than the defendant, therefore causing the collision. The trial court says, what are you relying on? I have a traffic study. It has no connection to rendering this type of opinion. And again, the discretionary decision of a trial court after conducting an extensive hearing with this expert in the room and issuing a lengthy order saying that it's not based on sufficient facts or data, that is a discretionary call that was absolutely correct based on what was presented to the trial court at that time. There are 4 other issues that I'm happy to answer any questions about that you didn't get to with the appellant's counsel. Otherwise, I'll cede the remainder of my time.
All right, thank you.
Thank you very much.
Okay, you have 4 minutes left.
Your Honor, to the issue of the in jury instruction, the case cited by Appellee's counsel, the Warfel case, the insurance case that he cited, actually underpinning that, the cases that are cited therein actually give us a sense of what really requires for fundamental error, and that's the Ray versus State case and the Sheffield versus Superior Insurance case, which is actually a Florida Supreme Court case from 2001, and which is a civil case. In the Sheffield case, which is relied on by Warfel, it stated that a party may not make or invite error at trial and then take advantage of the error on appeal. That implies it allows the jury instruction to be read, doesn't raise it, doesn't bring it up as an issue at trial at all, and then seeks to raise it in a post-trial motion of some type. Here, appellants didn't seek to take advantage of anything. What they did was, even though they went through the charge conference, didn't object, as soon as it happened, and with plenty of time for the judge to issue a curative instruction and to address the issue, they sought to avoid the error. They moved for a curative instruction, and appellants did not invite error. They sought to avoid error. And even though there are 2 options, the only option in the jury instruction that allows all the provisions of the wrongful death statute to harmonize is the first one, and that's what the Bell South versus Telecommunications case states by the Florida Supreme Court. So if you have no other questions, I'll cede my time.
All right, thank you.
Thank you.
Okay.